Hello, I'm Dominic Walker. My guest is Richard Glover. Richard is a partner within JMW's property litigation department. And Richard, I wanted to talk a little bit about a recent court decision, Prime London Holdings 11 and Thurlow Lodge Limited. I guess for most people, the name of the case isn't as important as actually what happened in the case. And it's all about access to neighbouring land, isn't it? So what did happen?
Hi, Dom. Good morning. Yeah, it's quite an interesting case. Access to Neighbouring Land Act has been around since 1992, but this is the first time in over 30 years that the High Court has actually considered what the test should be for granting an order permitting somebody access to their neighbour's land for the purposes of undertaking works on their own property.
And so what did the court decide and how did they come to the conclusion?
An access order is an order which allows you to go onto your neighbour's land to either repair or undertake basic preservation works to your own property. So the claimant in this case was a firm called Amber House, which was being redeveloped into a super prime property. The next door neighbour was also a developer, and they were also developing their property into a very expensive residential property. The claimant had requested access to a passageway on the defendant's land so that they could put some scaffolding on their land in order to re-render and repaint the north wall of Amber House. But in this case, the defendant refused. And so the claimant was left with no other option, if it wanted to do the works in the way in which it intended, to apply to the court for an access order under the Access to Neighbouring Land Act. Well, the court decided that a five-step test should be applied when deciding whether access should be given to your neighbour's land for the purpose of doing works to your own land. So very briefly, it's are the works reasonably necessary? They can't be, for example, where you are wanting to do home improvements or improvements to a building. They've got to be necessary for the preservation of land. Would it be impossible or substantially more difficult to do those works without access to the land? What, if any, inconvenience or disturbance or interference with use of enjoyment of the neighbouring land would result from access being given? And to what degree that inconvenience or disturbance would be. So it was decided that any minor inconvenience or where it wasn't going to impact on the neighbours too much, then it wasn't sufficient to say that there would be an unreasonable interference with the use and enjoyment of their land. And in those circumstances, access should be given.
So how can you help anyone in a similar situation?
Well done. We'd always encourage any client that came to us to have an early conversation with the neighbour if they're looking to undertake any works to the property, whether it be development works or remedial works. We act for many property developers or individuals who are undertaking works which may require access to neighbouring land. And our advice would always be to approach those neighbours to try and reach an agreement which permits that access. Those agreements are called access agreements, and obviously would be far better than having to resort to court action. If you've not been able to reach an agreement with your neighbour, then we can of course advise on whether you would be able to go to court and get an access order and the strength of your position on that. Now, that can benefit you twofold. Firstly, it lets you know the strength of any negotiating position you've got with your neighbour. So if there is a commercial deal to be done, you know the likelihood of you being successful at court. And secondly, if again, once you've been through a negotiation, you can't agree an access order with your neighbour, then we are obviously happy to go to court and try and get an access order for you.